You are watching PR English Shorthand Dictations YouTube channel.
This is English Shorthand dictation number 387 and the dictation speed is 120 words per minute. Ready? Start. The learned counsels appearing on behalf of both the parties have argued at length on the merits of the case and the point of law in question. The said ambiguity in the impugned point of law caused by the conflicting decisions of the two high courts has the potential to cause great harm to the fundamental rights of accused persons presently dealing with similar litigations and future accused persons who might also have to deal with similar litigations. In such a scenario, wherein such a length of time has been devoted by the parties and the court, this court sits in a unique position wherein it is equipped with all the necessary knowledge to clear the said ambiguity. If such an opportunity to clear the said ambiguity is not exercised by this court, it would so happen that at some point in the future, this court would again be tasked with answering the same question of law, for which a great length of time would again be spent by the court to complete the same task which could have been dealt with at an earlier time. Such a lack of exercise of its jurisdiction by the court would not only increase the burden on the pendency of matters but will also subject litigants from across the country to further pendency. It is therefore imperative that this court, at this instance, remedy such a mischief to save the court and future litigants from multiplicity of proceedings and mischief caused by such ambiguity in so far as maintainability of the present writ petition on grounds of deviation from the initial prayer is concerned, it has been held in a catena of judgments that this court, under writ jurisdiction, is not bound by the relief sought and can go beyond the original relief in order to meet the ends of justice. Further, in such a situation where there is a conflict of opinion on a legal issue between two high courts, mere technical objections cannot be allowed to stand in the way of exercising our powers conferred by way of Article 32 of the Constitution of India. The present appeal is by accused number 2. The appellant has challenged the judgment and order dated 12th January 2009 of the Punjab and Haryana High Court, by which appeal preferred by the appellant and accused number 1 against the order of conviction by the Sessions Court has been dismissed. The Sessions Court convicted the appellant and accused number 1 for the offences punishable under Section 302, read with Section 34 of the Indian Penal Code and Sections 449 and 324, read with Section 34 of Indian Penal Code. The appellant and accused number 1 were sentenced to suffer life imprisonment for the offence punishable under Section 302, read with Section 34. For the offence under Section 449, read with Section 34, they were directed to suffer rigorous imprisonment for 7 years. For the offence punishable under Section 324, read with Section 34 of Indian Penal Code, they were sentenced to undergo rigorous imprisonment for 1 year. Both the appellant and the accused number 1, Rinku, preferred appeal before the High Court, which has been dismissed by the impugned judgment. First information report was registered on the basis of the statement of PW1 Rahul, who was 11 years old at the relevant time. He is the youngest of three sons of the deceased Renu, and Satpal. According to the prosecution's case, on 30th December 2002, Rahul and his mother were sleeping in their house by locking their house from inside. Rahul's elder brother was staying in Ghaziabad for education, and his second brother had gone to stay with his maternal uncle. Rahul's father Satpal was working as priest of a temple and he was residing near the temple. He was not residing with the deceased. According to the prosecution's case, at about 1 a.m., PW1 Rahul heard the noise of his mother. When he woke up, he saw that accused numbers 1 and 2 were grappling with his mother. Accused number 1 Rinku by knife inflicted 6 to 7 blows on the stomach and chest of the deceased. At that time, accused number 2 was holding the hands of his mother. When Rahul tried to rescue his mother, accused number 1 inflicted injuries on him with the same knife. Thereafter, both the accused fled away. They had entered the house through a window and they went back through the same window. According to Rahul, he was hiding in the house due to fear. At about 5 a.m., when a milkman who is described as Golu by PW6 came to the house, Rahul came out and disclosed to the said milkman that the accused had murdered his mother with a knife. The said milkman reported the incident to Rahul's uncle Rajan Singh, who came to the site. Thereafter, Rahul's father Satpal also came. An injured Rahul was taken to hospital where his statement was recorded. Based on his statement, first information report was registered. The learned counsel for the appellant has taken us through the evidence of the material prosecution witnesses. He submitted that evidence of Rahul will have to be tested very carefully as he is a minor witness. He pointed out that there is absolutely no corroboration to the testimony of the minor witness, which is full of material contradictions and improvements. He submitted that evidence of PW1 Rahul is not reliable. He pointed out that according to the prosecution's case, Rahul did not disclose the incident till early morning to anyone. He disclosed it for the first time to the milkman Golu, who came to his house around 5 a.m. In fact, PW6 also claims that he heard the said milkman saying that the deceased has been murdered. He submitted that the prosecution has not examined the milkman, which is fatal to the prosecution case. He has submitted that the presence of Rahul at the time of the incident is extremely doubtful. He submitted that there was complete darkness in the house at the relevant time and therefore it was not possible for the witness Rahul to see the accused. He urged that there is every possibility that the witness Rahul was tutored. In any event, he submitted that a very limited role has been ascribed to the appellant of holding the hands of the deceased while accused number 1 assaulted her with a knife. The learned counsel, appearing for the state while supporting the impugned judgments, submitted that there is no rule that for maintaining a conviction on the sole testimony of a minor witness, corroboration is necessary. He submitted that alleged contradictions and improvements in the testimony of minor witness Rahul are totally insignificant, which do not make his evidence unreliable. He would therefore submit that no interference is called for with the view taken by both courts